Everyone, welcome to the Environmental Law Institute and the Environmental Defense Fund's event, Community Lawyering for Environmental Justice Part 13, Energy Affordability and the Power of Community Voices. My name is Madison Calhoun, and I'm ELI's Educational Programming Attorney. Thank you all for joining us this afternoon. We have a wonderful program in store for you today. Before we get started, I want to take a moment to thank the team at EDF, as well as each of our wonderful speakers for all of their work to make this program happen. Today's event is the 13th part of ELI's Community Lawyering for Environmental Justice series, designed for attorneys to receive continuing legal education credit through practical education about the practice of law in relation to environmental justice. Our speakers have prepared PowerPoint slides for this program, so please be sure to download the written materials from the event webpage. We will post the link to that in the chat. You can also find our faculty biographies there. I want to take a minute to go over the continuing legal education component of this program. ELI is an accredited CLE provider in Vermont and Pennsylvania, so this program is automatically approved for 1.5 hours of standard CLE credit in those states. ELI has not applied for CLE credit in any other states for this program, so please check with your state's CLE guidelines to see if your state offers reciprocity with the states in which we are pre-approved. If you're seeking CLE credit in a state which does not offer reciprocity with Vermont or Pennsylvania, you'll need to apply for CLE credit individually with your state. We will email out certificates of attendance to anyone who requests one after we have verified their attendance. Certificates of attendance are used to verify attendance for CLE purposes, and in many cases, attorneys can use these to apply for individual CLE credit with states. To receive a certificate of attendance, you must be online throughout the entire program. We'll be verifying this with our software's attendance report. You must fill out the certificate of attendance request form after the webinar. This was sent out via email before the program, but we will also post a link to that in the chat. And lastly, you must submit the correct code in the request form to verify your attentiveness. We will read out the code at some point during today's webinar. We'll also post it in the chat. Should you have any questions related to CLE, please contact us at cle@eli.org. Today's program will be recorded and posted publicly to ELI's website and YouTube page. Additionally, we will be taking audience questions at the end of the program, so please feel free to put your questions in Zoom's Q&A box as soon as you think of them. While the chat will be open for you to post observations, please put any questions that you wish for our speakers to address in the Q&A box. I will now go ahead and turn things over to our wonderful moderator. Thomas Lutkin is a science fellow at the Environmental Law Institute, whose work has focused on clean energy and decarbonization. At ELI, Tom supports the Climate Judiciary Project and programming on the energy transition. Tom, I will hand things over to you. Thank you so much.
Thanks, Madison. And thank you, everyone, for joining us for today's discussion. As Madison mentioned, my name is Tom Lutkin. I'm a science fellow here at ELI, and I focus on energy and energy transition topics. It's my pleasure to be today's moderator with you all today. So our webinar is going to focus on energy affordability and the power of community voices. And as Madison mentioned, it's part of ELI's long-running community lawyering series. The eagle-eyed among you will have noticed that this is part 13 of that series. It began in January of 2022. Over the years, ELI has covered a range of environmental justice topics, including how lawyers and legal professionals can work with non-legal experts, technical topics like PFAS and their environmental justice implications, and generally examined how lawyers can support their communities not only in the traditional avenues of the law, but also in these community lawyering spaces. So we're going to be discussing energy affordability. I wanted to briefly mention some numbers around why this topic is so important. This will come up later. I have already seen Justin's presentation, but according to the Energy Information Administration, in 2022, over 33 million households, which is roughly a quarter of the total US household count, fit the Energy Information Administration's definition of energy insecure or energy insecurity, which means that members of the household could not adequately meet their energy needs. This can be caused by a number of factors: high energy prices, high electricity prices, also by physical infrastructure, things breaking down. It's oftentimes a combination of both of those two exacerbating one another. From a justice perspective, energy is a ubiquitous cost, but it's very regressive. Lower income households are affected most by a rise in energy prices. And additionally, vulnerable communities, often communities of color, are hit hardest of all, making energy affordability a key element in tackling environmental justice as a whole. So I'm very pleased to be joined by our distinguished group of panelists today to help us dive into this topic. First up, we have Justin Schott from the University of Michigan. Then he'll be followed by Kurt Stokes from the Environmental Defense Fund, Mary Wamboy of the Planning Office for Urban Affairs at the Archdiocese of Boston, and Jolette Westbrook, also from the Environmental Defense Fund. We're going to get things started with Justin Schott, who's a lecturer on environmental justice at the University of Michigan and the director of the Energy Equity Project. In this position, Mr. Schott teaches about energy justice and equity and leads an interdisciplinary team of researchers, community advocates, regulators, and utilities to measure and advance equity in the energy system. He's served as an expert witness in numerous utility rate cases and integrated resource plan meetings. I'll turn things over to Justin to get us started. Thanks so much.
Great. Thanks so much for that intro, Tom. It's great to be with the panel today. Thanks to ELI and EDF for organizing. And I'm excited to share about our work and some of what we've been seeing around energy affordability. Just briefly, the Energy Equity Project, we're focused on ensuring everybody's got continuous access to affordable and clean energy. We support more than 25 frontline organizations in their energy justice campaigns, and we are regularly in regulatory spaces, making the case for affordability. So this is your 10-minute crash course. Energy bills are skyrocketing, and we are all along for the ride. We'll talk a little bit about what that looks like, add some more detail to what Tom shared, talk about who is being impacted, and then want to get to solutions just a little bit here. My hope is that we can make energy prices part of the national conversation in the same way that egg prices were dominating during the campaign. People are spending 10 times more at least on energy than they are on eggs. But for some reason, even though it's impacting a third of Americans, it just doesn't seem to have the same traction. Energy prices are outpacing inflation by about 50%. So this is 2021 to 2024. And the trends are getting worse as we're starting to see some numbers roll in for 2025. And most of these rate increases are really burdening residents, while the commercial and industrial customers have relatively flat rates. They're not experiencing these same rises. So to give you an example of what that looks like, here in Michigan, from 2010 to 2023, we saw more than a 50% increase for residents. Industrial customers, these are manufacturers, they are data centers, right? They are down at 15%. And then where do these higher and higher rates end up going? Some of this is operating expenses. Utilities do spend money to make sure that we get power. But about 20% of the bill is going to their shareholders. In this case, this is from Southern California. So both the net income and then the taxes that utilities pay on net income, those all come from us. So a significant chunk of these rising bills we know is going to utility shareholders. And it seemed like something clicked 4 or 5 years ago where utilities said, hey, we could just ask for a lot more money, even though demand has been relatively flat. And so we've just seen this really meteoric rise in energy requests. And as a general rule, in a lot of places, they request double what they actually expect to get. And that's pretty reliable. The shareholders, not surprisingly, have been pretty favorable seeing this happen. So this is DTE again, 50% increase roughly in stock prices over the last 6 quarters, and accompanied by 1.4 billion in net profits. I won't spend a lot of time talking about these additional pressures that are coming, but cooling costs are much higher than heating costs generally for people, and will continue to go in that direction. We know there's this additional return on equity as bills get higher that we'll be paying. Data centers, huge driver of increased demand that's gone from flat in many places to projected to be 50% higher in the next few years. We're not sure how much of this exactly will materialize. And And then as people can't afford their bills, right, they pay more fees on top of that. So late fees, we found some households were spending as much as 3% of their income just on the late fee component of their bills. And these are big sources of profits for utilities as well. Being a utility means you're generally not on the hook for mismanagement or the risk that comes with things like climate impacts. Those again fall on customers. And there's less and less assistance that's available and frequent threats to keystone programs like the Low-Income Home Energy Assistance Program. And when people become energy poor, this doesn't just stay within their energy budgets, right? This affects their total household budget and financial security. And it means that energy prices are a top concern for people. And again, I think this is something under the radar. It's not just housing affordability. We generally talk about energy prices as a top 2 concern that people have financially. And we've seen this in other places, not just in Detroit. We've seen it in regional surveys as well. So energy affordability, this is generally defined as 6% of income being the maximum threshold that you spend on energy. If you're wondering where this comes from, that's a portion of 30% housing threshold. So people have said if you spend 20% of your housing budget on utilities, 20% times 30%, that gives you a maximum of 6%. It's unclear whether that was supposed to also include water, internet, phone, what they were talking about as utilities. But you get to this 6% energy burden if you've got a $50,000 income and a $3,000 or $250 a month energy bill. We know a lot of people are much, much higher than that. So in places like Detroit, we see something like a quarter of the population spending about a fifth of their income on energy bills. There's not a good term for this. We've deemed these catastrophic energy burdens. So the impacts of unaffordability, there's a lot going on here. This is a census tract scale map. And so on the bottom left, you'll see different income brackets. So on the far left, this is everybody below 100% of the federal poverty level. And you can see they've got these red energy burdens generally. So these census tracts, people are spending upwards of 15% of income on energy. And then as you get to wealthier communities where people are making upwards of 100,000, they're generally spending less than 3% of their incomes on energy. And so the good news is the total system has some surplus, right? We have some people that are really struggling, but if everybody else paid a little bit more, we could, and you can see it just visually, right? The height of the green bars is enough to take care of the left red bars here. So when people are energy insecure, they can't keep up with their bills on a monthly basis. They're already making other cuts to what they're spending on food, on healthcare, on transportation. They're keeping their home at unsafe temperatures, so they spend less per square foot generally than wealthier households on energy. And even so, they experience frequent shutoffs. The data on this is not very good, but we extrapolate to about 7 million shutoffs per year. So, 1 in 5 of these energy insecure households gets shut off. You may have a 10% risk in a given year if you're energy insecure, but over time, right, that increases. So something like a quarter of households may be shut off over a 5-year period. The amount of hours that people are shut off is much greater from shutoffs than it is from kind of natural power outages from things like ice storms. Being on a low-income assistance program doesn't protect you. If you are a person of color, you're much more likely to be shut off. And utilities are spending a lot of our ratepayer dollars in collections and in actually sending out field crews to conduct the shutoffs. The data that we have is a patchwork in states where shutoffs are the highest. We've seen about 1 million over the last 3 years in places like Michigan, Illinois, and Virginia. I think other states are probably worse. We just don't have data from them Florida Power and Light, for instance, a single utility recorded almost 1 million shutoffs, and then they stopped being required to report due to some commissioner transitions ushered in by Governor DeSantis at the time. Here's just an image of racial disparities in shutoffs. This was from a survey of the winter 2021 to 2022. And disturbingly, it's not just racial disparities that we see, but households with children. This was almost a third of households with kids under 5 from a survey of about 1,000 households experienced a shutoff here while COVID was still pretty high. We see major disparities by census tracts. Some of this is income-based, but some of it goes back to housing discrimination. So high correlation between redlining and inefficient housing stock, which leads to higher energy burdens. And in general, right, you'll hear a myth that we can't subsidize people to make their bills more affordable. It's just unfortunate that we have people with such high bills. And I want to combat that a little bit and say, most of our incentives, things like EV tax credits, are going to the wealthiest households, and the bottom 60% or so is subsidizing a lot of that. We're subsidizing, right, or committed to these big shareholder profits, even though those are above what many analysts think is necessary to attract capital. And again, we've got these major disparities on how energy insecurity is experienced. Also, if you've got a disability, if you lack internet or medical insurance, it's particularly bad. And then bottom line, we just don't have a safety net that is sufficient to serve people. 4 out of 5 households who are eligible don't get it. And then most of the money that's there is not actually helping people to lower their consumption. So solutions, again, good news. We've got on the right there, the surplus in green compared to the gap that people can't afford. Much, much greater surplus than we have. So how do we redistribute that among the people who can afford to pay a little bit more, among those commercial and industrial customers? How do we use some of these savings that we get from reducing write-offs, right, from bad debt, and putting those into affordability programs? And then there's a lot to be had, I think, on the return on equity. And it takes just a small decrease in profits to bring people pretty significant benefits on the affordability side. I'm going to move past this. There's some more resources and citations within the slides, but this was just thinking about how do we use savings in other areas of rate cases to support affordability programs. It's not that expensive. This was a proposal in upstate New York that would cost people about $3 a month to eliminate burdens above 6% for people below the poverty line. And yet we still have unaffordability, right? And I think that comes down to this idea, ultimately, that people are responsible for their own bills, that utilities are just set up to make a profit, that we need to trust them as they are putting in these 5,000-page testimonies and exhibits, right? That we don't want to risk things or potentially face outages or higher costs of capital. And then at the very least, right, we should study it more. We should look into it for a few more years before making a rash decision that ensures everybody has affordable energy. So I will leave it there. I'm excited to answer questions and then to be part of the broader conversation. So back to you, Tom.
Thanks so much, Justin. I'll take a little moderator's prerogative. As a short follow-up on that presentation, could you maybe give an example of a model affordability program? Also, maybe what happens when we don't get this kind of program right?
Yeah, one that we've been really supportive of is in the Twin Cities. Xcel Energy is the investor and utility there, and they've recognized that it's pretty costly to do all of this income verification, right? To say, well, if you have an 8% energy burden versus a 12% energy burden, how do we deal with that? And so they've just taken entire census block groups, so about 1,000 households, and said, look, we know energy insecurity is pretty endemic here. We're just going to automatically qualify everybody and give everybody a bill credit based on the average energy burden. So yeah, big saver on administrative expenses. People don't have to go through the difficulties of applying and reapplying and revalidating their incomes. And that's just getting started, but I'm hopeful of that kind of community-wide assistance program model.
That's fantastic. Thank you for that. So eager to hear more, and I'm sure we'll get some questions for Mr. Schott when we get to the Q&A portion. But I wanted to move on now to our next speaker. We'll hear from Kurt Stokes, who's a senior attorney at EDF. Kurt represents EDF before state utility commissions, where he seeks to align public utility plans, programs, and investments with climate and equity goals. Also accelerate the transition to cleaner energy, and to collaborate with those disproportionately burdened communities to elevate their voices and advocate for energy justice. So on that, Kurt, I'll turn it over to you.
Thank you, Tom, and thank you, Justin, for starting us off and really painting a good picture of what we're up against. Yeah, as Tom mentioned, I'm a senior attorney at Environmental Defense Fund. We have a program, Community Voices in Energy, that we try to elevate communities at the Public Utility Commission level. It's really a good way, I think, a good model of advocacy to make an impact on affordability and other issues that face communities, because affordability is usually just one of many issues that how energy impacts people. Going to the next slide, as you mentioned, we do represent EDF before state utility commissions. That's just it's a manifestation of our overall mission to, 1, stabilize the climate, 2, strengthen people and nature's ability to thrive, and 3, support people's health. And when we represent EDF before public utility commissions, some of the lessons learned in doing this in multiple states, Illinois, Jolette, who's coming up later, she's in Massachusetts, but we also have folks who have worked in California, Texas, New York, New Jersey. But the overall lessons are, there are a lot of different ways to make an impact when you're working with a community and a community member. The first is to consider, like, what type of proceeding the community wants to get involved with. Is it one utility that is a problem and they want to intervene in a rate case? The bar there to intervene is going to be a little bit higher than maybe just commenting on a rulemaking or just going to meet with a commissioner to express concerns. The type of proceeding matters, but you can usually make a bigger impact statewide by engaging in something like a rulemaking, or asking the commission to open up a workshop, or holding a public meeting. Those things can be effective, especially if communities are invited to participate in those. And you can usually make a bigger impact with a smaller budget, because you're not hiring expert witnesses, you're not engaging in discovery, writing briefs, all that kind of stuff. If you do end up in a contested proceeding like a rate case or an IRP, that's an integrated resource plan where you're, like, looking out into the future. Or if you're looking at things like energy efficiency dockets, you might want to look at your local PUC rules, because there are several PUCs that have different levels of intervenor status. Every PUC that I'm aware of has a full intervenor status. That's where you're actually a party to the case. You have rights in discovery, to present evidence, and to participate in oral arguments and write briefs. Usually those cases will have ex parte rules about contacting the judges, staff, or the commissioners themselves. So they're providing that legal guidance to kind of demystify that process for the community is really valuable. But if you're facing a tighter budget, several states have a kind of like a secondary intervenor status where you don't get discovery rights, you don't present evidence, but you can still file a brief. And if anybody's done like an amicus brief at a court before, it's very, I can compare it to that. That, you look at the evidence and you're just filing a brief trying to help the commission understand the issues in that case from the community's viewpoint. So if you're facing a tighter budget, that's something that you can still make an impact with. Funding sources is another consideration. Jolette will get more into detail on this, but there are multiple states out there. And I think we have a handout from NARUC, the National Association of Regulatory Utility Commissioners, that identify states with intervenor compensation programs. that allow interveners to apply for public funding for participating in cases before the commission. And one thing, Justin mentioned earlier, like 20% of your bill goes to utility profits. But not everybody knows this. Most people on this call might know it, but utilities collect their attorney costs and expert witness fees from ratepayers as well. So like they're usually the only ones in the room that don't have to pay their own way into a rate case. They're just collecting it from ratepayers. And these intervenor compensation statutes and mechanisms really help level that playing field. And then the last thing we want to focus on is if you can set up your organization so that you're actually representing a community, that's great. That's easy. You've got attorney-client privilege. All those things apply. But if you're not, and EDF is not, we're not set up to represent other parties. But you can still identify communities that need a voice. And I would really encourage you to consider whether your organizational mission allows you to work with communities to elevate that community's voice in a commission proceeding, just as a community witness. EDF has done this in Illinois and Massachusetts. I'm gonna go through a case study that we did in Illinois. Our witnesses were not clients, but they made a huge impact on the case. And I really think that if your organization is in this situation, helping other communities elevate their voices is valuable. It builds a better atmosphere of cooperation and collaboration between environmental groups and the communities that they're serving. It really strengthens the voice of the communities that we're serving in our capacity as a nonprofit anyway. So I would encourage that. This is our case study was our community witness, Cheryl Watson, who's a very active member of her community in Chatham, which is a community in Chicago. And she discussed in her testimony the importance of disconnection protections, not just for low-income customers, but customers with chronic health conditions. She talked about how important it was for customers with weatherization and energy efficiency needs to be able to work with the utility to overcome the barriers that low-income customers have, and to combine the weatherization and energy efficiency programs with other programs like demand response and like the smart thermostat programs that can really magnify the gains from energy efficiency and weatherization investments. She also talked about the importance of air quality. So in Illinois, one of the important provisions of the Climate and Equitable Jobs Act of 2021 was to be able to deliver benefits of grid investments to what are called equity investment eligible communities, which are environmental justice and low-income communities. Generally, I'm overgeneralizing the statutory definition, but her concern was growing up in Chatham in the 1960s, there were steel mills close by. And she talked about how that affected the air quality in her neighborhood. And with the Clean Air Act updates, those steel mills had to clean up their act. And by the 1990s and 2000s, the air quality in her neighborhood improved significantly. But then with more investment, one of those steel mills came back. And she talked about how 50 years after growing up, she was able to taste the smell and taste the oil and the emissions in the air again after it had been cleaned up previously. So when we talk about benefits and jobs that come with grid investments, it's important that those jobs and investments come with clean energy and clean air, clean water benefits, and not just looking at dollars and cents. The last thing she talked about was power quality. So that is something that was really important to Justin earlier was disconnections. Ms. Watson was able to testify about how when everybody in her neighborhood turns on the air conditioning, the power flickers. And we were able to partner with an expert witness in this grid proceeding to disaggregate power quality data to show that there are pockets, even though the overall reliability of the system in Chicago is very reliable, there are pockets where this is an issue. And Ms. Watson's testimony really on all of these issues partnered with a expert witness to talk about what the lived experience was for this for her community. And overall, I would say we were very, very effective. On disconnection protections, ComEd agreed to a disconnection program where if you had applied for assistance, you were automatically pulled off the disconnection list until your application for assistance was processed. ComEd also developed a 5-tier low-income discount rate. On power quality, the commission required ComEd to engage in regression analyses and future grid plans. I think the commission did a good job of considering air quality in ComEd's grid plan, consider it holistically. The challenge that we had, though, was for programs that have like dedicated dockets like demand response, energy efficiency, rate design. The commission was still like, it noted ComEd's energy efficiency and weatherization programs, but it didn't consider it holistically. So that's a remaining challenge. And just like to go to Justin's point about low income discount rates, this is the part where the order on refiling, the commission did approve and noted positively ComEd's proposal to do this low income discount rate. So I went a little bit over time. Sorry, Tom.
No, never apologize, Mr. Stokes. That was excellent. I wanted to take advantage here again. We had a somewhat similar question come up in the chat about compensation. So I just wanted to prod you a little bit on that. So we had talked earlier, because you also brought up the compensation for the utility side in a rate case. What are the compensation rules, so building off the question from the Q&A, compensation rules for any legal advice, so lawyer fees, but also for witnesses? Can witnesses be compensated for their time or for other expenses when they are participating in these proceedings?
Yes. So the NARUC handout that hopefully we can share with this presentation has a summary of every state's intervenor compensation program. Some of them, I think most of them, will cover attorney's fees. So if you're a community member and you want to go out and find a law firm or a legal clinic, there is a way to get paid for that. They will also pay for expert witnesses. For fact witnesses, if you want to call a fact witness and compensate them, you're going to have to consult. I would recommend you consult with your state bar ethics rules. For example, Illinois allows for like reasonable expenses like time, travel, incidental expenses like meals, childcare, adult care, and like a reasonable time to attend depositions, hearings, consulting with the attorney, that kind of thing. But that's going to be state specific, and I would encourage you to look at your individual rules. I think it's Rule 3.6 and Comment 3 on Missouri on the rules about professional ethics for most states.
Thanks so much, Kurt. And we're really excited for our next speaker. We have Mary Wemboy, who's the Director of Asset Management, Resident Affairs, and Energy for the Planning Office for Urban Affairs, which is a nonprofit social justice ministry of the Roman Catholic Archdiocese of Boston. She's also a senior fellow at Mass Inc. and serves as a counselor on the Massachusetts Energy Efficiency Advisory Council. In her work, she represents residential energy consumers and is widely recognized as a leader and advocate for housing, climate, and energy justice. So, Mary, thank you so much, and the floor is yours.
Thank you, Tom. I hope you can hear me. So
Yes,
I'm here. Okay. So my beginning slide is titled Including Community Voices in Rate Making, and it's really a call to action. I recognize that a lot of people in this webinar have the power to make this inclusion a reality. So I wanted to lay down my foundation for advocacy, just to share about the kind of people you may find in your towns and your cities that you can assist in making energy affordable. So that's a picture of my family way back in, I'm the little girl in the green dress there. So I come originally from Kenya. And so issues of equity, justice, affordability, and creating a level playing field are something that I carry in my heart. I have been working for 16 years here in Massachusetts in affordable housing. Housing and energy affordability are intertwined, and there is no way to separate them. I don't believe you can have one without the other. I also live in Lowell, Massachusetts, which is how I ended up in the rate case that I was a part of. Lowell is a gateway city, it's energy burdened, and my advocacy is really born from direct experience and a shared struggle. So why did I testify? So I'm just telling my story when I testify. So the image on my slide is the image of a proposed network geothermal project, which was supposed to be a collaboration between our city's utility, a local university, and municipal leadership. But the community was not really represented. So this project was it was positioned as a model for equitable climate solutions, energy access, and affordability. And then without warning, it was quietly withdrawn, no explanation, no community dialogue, and no transparency. This is exactly why I testified, because the energy company that was in this picture here is the same energy company that actually had a rate case. So basically, centering community voices is not just crucial, it's the bedrock of true justice. And we need to actively challenge unjust rate increases and not just question them. We need to advocate for transparency and accountability. Our energy system is full of systemic inequities. And without the partnership between the experts and the people who are experiencing these struggles, then there can be no change. So what were the issues? This was a rate case in Massachusetts. We had 60% increases in up to 60% increases in our monthly bills, and even like school systems were affected, and it's in communities with less resources, underinvested communities. So the proposal by the energy company, for me and many others like me, was not just insufficient, it was a betrayal of public trust. Rate hikes, as Justin has alluded to, they don't offer real community benefits. In fact, they just burden those who can least afford them. Any incentives, if you think about energy efficiency, are usually rigged and prioritizing shareholder profits over the fundamental right of customers to affordable energy. Things like heat pump access, especially for those who are below 60% of AMI, who are heating with oil and delivered fuels in Massachusetts, is just disproportionate. Those with the money, they can get heat pump access. Those who have high bills and have less resources cannot get this type of technologies. So those were our issues. So what were our recommendations to the department? We we asked for, incentivizing heat pump access for delivered fuels customers. We also asked for deeper discount rates for the lowest income customers. We also asked for the promotion of workforce diversity, and we also required more inclusive community engagement. This particular rate case was very interesting. People who live in the community heard about stakeholder engagement from people who do not live in the community and are not even served by that agencies. So our communities deserve a seat at the table from the very beginning. So what are our key wins? I think one of the things that I learned during the rate case was that having community voices during a rate case does not only affect the proceeding that is ongoing, but it can have other benefits outside of the rate case itself. In the case of Massachusetts, we had our energy efficiency planning going on at the same time when this rate case was ongoing. So we had key wins, which were the regulator ordered National Grid to develop a special rate. There were some retroactive discounts, tiered rates, and affordability at a more deeper level. And then since I'm at the Energy Efficiency Advisory Council, I believe that having community voices before commissioners may have influenced the positive outcome in our energy efficiency 3-year plan as far as equity-related investments were concerned. There was an increased focus on low and moderate income electrification compared to earlier years or earlier plans. So legal intervenor support matters. I am not a lawyer. I'm not an energy expert. My work is in housing, and all I know is about my own struggles with my energy bills and living in a house, a rented apartment that was really way up there in terms of energy bills and not very efficient and not even very healthy. So with that background, I know my problems, and I know my neighbors' problems, but I recognize that there is a legal process here that most of us with this limited background cannot be able to successfully have systemic change. So energy justice needs your legal muscle. I also collaborated with the EDF's outside counsel to shape my testimony. It was grounded in my own convictions, but the language was refined to maximize impact. I also had strategic guidance. My talking points were aligned with DPU procedures, something I could not have done alone. The outcome was that my testimony resonated with stakeholders and has advanced our energy justice goals. Yeah, I guess that's it. Thank you.
Thank you so much, Mary. I know that we'll have, I have a couple questions, and I know that that is such a valuable perspective to bring to this discussion. And I do want to make sure that we are, moving with alacrity through things, but we will definitely circle back to particularly how that interaction that you mentioned there at the end, how the legal and the community, elements can combine. That was fantastic. But first, before we get to those Q&As, I did want to make a little space here for our last presentation from Jolette Westbrook, who is the Director and Senior Attorney in Regulatory Solutions at the Environmental Defense Fund. In this role, Ms. Jolette leads EDF's efforts to improve and reform wholesale markets, and also works to advance EDS objectives before state public utility commissions. Her extensive energy regulatory experiences also include her former position as commissioner at the Massachusetts Department of Public Utilities and director of Massachusetts Energy Facility Siting Board. Say that 3 times fast. So, Gillette, over to you.
Thank you very much, Tom, and I really appreciate the opportunity to share my thoughts regarding affordability and the importance of community input in the energy regulatory space. You've already heard today why we can't wait. Justin has talked about energy burden, energy insecurity, and the number regarding outstanding utility debt is staggering, in my opinion. Justin talked about disconnections. Those are real. And think about it. As we're getting warmer and warmer summers, not all states have heat-related shutoff protections. So people are having difficult times whenever their utilities are disconnected, be it in the winter or in the summer. So affordability, Justin mentioned some solutions. In my opinion, we need a holistic approach. Electricity rates, you heard Kurt and Mary talk about a tiered discount structure whereby those most in need get the greatest benefits. That's one part of it. We need to look at overall energy costs. So how much are the energy resources that are providing the energy costing? And community input is just so important. Mary, I thought your comments were very compelling. And we have to make sure, I think, that the communities are aware of what's going on with respect to the energy space. It's more than just flipping a switch and having the lights come on. The community needs to know what type of energy infrastructure may be planned for their community, what they can do about it, how they might be able to shape what is going to happen, and also, what are the impacts? Are there impacts? Are there affordability impacts? Are there environmental impacts? And as Mary indicated, and as Kurt indicated with the testimony given in the case in Illinois, real stories from real people can create real impacts. So engaging the community, there may be questions out there about, well, how long has this been going on? And I can share with you the road to what I call the road to community engagement in Massachusetts. This has been going on for a while. About 4 years ago, the Attorney General's office in Massachusetts convened a stakeholder working group, and EDF was fortunate to have a seat at the table. The working group, we were tasked with identifying barriers to participation in the DPU and EFSB proceedings. That's Department of Public Utilities and Energy Facility Siting Board. But not only were we tasked to look at the barriers, we were tasked with coming up with solutions. The working group met for about 18 months. And I do want to highlight that we felt it was very important that we just not huddle among ourselves, but we needed community input. We retained a consultant. who conducted focus groups, interviews, and surveys. And the result was a report entitled Overly Impacted and Rarely Heard. And I have included a link to that report in my slide. This report, I think, just was so helpful in elevating the problems that exist with communities getting involved in a very legally complex proceeding in front of the energy regulators. The report has over 40 recommendations, and they're short-term recommendations and they're long-term recommendations. Some recommendations require statutory change. Some recommendations the regulatory entities can implement themselves. And I included a few of those recommendations. EEA is the Executive Office of Environmental Affairs. In Massachusetts, we pushed for the establishment of an Office of Public Participation and Support. That has been done. We pushed for an amendment so that the composition of the Energy Facility Siting Board would change. We really believed that there should be at least one board member with experience in environmental justice issues. That was put into legislation toward the end of 2024. And because of the complexity of the legal proceedings, we also recommended the establishment of an intervenor support fund. And that as well was incorporated in legislation at the end of 2024. The fourth bullet you see is that the DPU commissioners increased their public visibility. What was interesting was in talking with people, a lot of people didn't even know that a Public Utility Commission existed, or a PSC. They're called different, they have different acronyms. And I will say, to its credit, the Massachusetts DPU held a series of road shows, they called them, where they went to communities. They held some in Boston to explain in plain language what the DPU does. You've heard, well, Kurt talked about PSC proceedings, and I won't repeat what he said in terms of the importance of pairing community expert witnesses with technical expert witnesses. But I will say that in my experience, I think it's really key when engaging in front of an energy regulator that what you bring to the table is presented in both a clear and concise manner. The records in these proceedings can be very lengthy. I mean, they could be well over 1,000 pages. I mean, think about it. It's the filings, it's the discovery, it's a lot. And so to be concise and to get your point across as clearly as possible, I think is really, really important in PSC proceedings. I also want to park for a minute on intervenor compensation. Kurt raised it. It's important. Again, the complexity of these cases is the magnitude is, it's just overwhelming, I think, for people who don't engage in it every day. And Kurt mentioned that there's about 22 states with intervenor compensation programs. That's changing. And Massachusetts, as I mentioned, we have a statute that now allows for intervenor compensation. And we are in the process right now of promulgating regulations. Draft regulations came out very recently, just a couple weeks ago. And so now, of course, it's digging in the details and really figuring out how to make intervenor compensation accessible and so that it will be used. I mean, isn't that the point? To have it used. So I want to maybe just spend the next 2 minutes or so, because I'm probably close to time, talking about some of the draft regulations in Massachusetts and other states as well. So most states that have an intervenor compensation program will have a requirement that there be a demonstration of significant financial hardship or something along those lines. Massachusetts is no different. And another requirement in Massachusetts is that the applicant needs to state and demonstrate their unique perspective. So how is the perspective that the applicant is bringing different from everyone else in the case? And in my opinion, that makes a lot of sense because the DPU wants to develop a record. They want different perspectives in there. And again, that's the purpose of intervenor compensation, to allow those groups that have not had a chance to sit at the table, bring their perspectives. So who is eligible for intervenor compensation? Well, under the proposed regulations in Massachusetts, they will, eligibility includes those organizations and entities that advocate on behalf of low and moderate residential customers. And also state acknowledged tribes or state recognized tribes. How much money is involved? The proposed regulations state that grants shall not exceed $150,000 for each party or $500,000 per proceeding. Now, I do want to highlight for a second that in looking at various intervenor compensation programs around the country, there's a lot of conversation about when payment is made. And the issue is if payment is not made until the end of the proceeding, how can attorneys, how can experts be paid? In Massachusetts, the proposed regulations attempt to address at least part of the issue by allowing applicants to receive up to 10% of the total grant if they demonstrate significant financial hardship, that they need this 10% of money up front. So the regulations are being promulgated. I expect that EDF will file comments regarding the proposed regulations, but I hope that people on this call will look at whether or not their state has intervenor compensation, and if so, look at ways to avail themselves of that resource. So thank you very much. And Tom, I'll turn it back to you.
Thank you, Jolette. That was an excellent presentation, and I think puts us in a great place to move to the audience Q&A portion. So I'll officially kick off that part of today's discussion. I'll take a first stab here and get things kicked off. I wanted to maybe circle back to Jolette and Mary, your presentation and your insights there. What was Was there an inciting incident? What really sort of kickstarted the work that that you all have done in Massachusetts in the first place?
I can start, and Mary, you may want to add to it. I don't think that there was any one incident. I think as utility rates continued to rise, as needed infrastructure was being developed, communities at public meetings were voicing their opinions and concerns about not fully understanding the process, wanting to know how to ask questions and get answers. Well, they know how to ask questions, but how to get answers to the questions, and answers that provide transparency, that are consistent, and they are, I think it was community concern about what was going on in their community that really prompted the stakeholder working group to take shape.
That's great. Mary, please, if you had any follow-ups there.
Yeah, I can add that for me, I represent residential consumers at the Energy Efficiency Advisory Council. And Massachusetts has an energy efficiency surcharge. And that surcharge comes from customers across the Commonwealth.
Mm-hmm.
But over the years, despite the Commonwealth being #1 in energy efficiency, our communities did not have any, did not benefit from energy efficiency. And as you know, reduced energy loads help in reducing energy costs. So these complaints and community concerns, I saw them in the EEAC and many other places. So it's basically community concern. And as I also said, it's also personal experience. Our energy bills are high, and yeah, so that's where the momentum comes from.
Excellent. I guess sort of pulling off of that, and then I will move to some of our questions from the audience. But Kurt, if I could pull on a thread where I think this might come up for you as well. What happens if when you're in this process, the legal side is probably more familiar with things like data requests or discovery requests. But what happens if a witness or someone from the community gets one of those discovery requests, perhaps after they give testimony?
Yeah, so that's one thing that we address like early on with the witness or the community is like understanding what the like the time commitment is that you might be subject to a data request. We try to keep it limited to data requests. I've never seen a witness in a utility matter before a public utility commission actually like have to like sit through like a deposition or do like more formal discovery like production of documents or anything. At least in nothing involving like less than like hundreds of millions of dollars. So they're not gonna you know do that to a community witness, I don't think. But it is a possibility. But walking through and like demystifying, like making sure that they understand the question, one, screening out improper questions for like raising proper objections. That's all that's important. But then crafting the answer with the witness to help them understand like their obligations to like do a reasonable investigation into what was being asked and getting all the information in response. That's just part of basic lawyering. But like having a lawyer help with that process is going to be really, really important. Having community witnesses just out there on their own trying to respond to a usually very densely worded compound question data request is going to be lawyers can really chip in there.
Thanks, Kurt. Yeah, that's I think that was a sort of top of mind question for some of our participants. I wanted to move to there's been a couple questions here on how people can get involved, and so I maybe wanted to turn to Mary and also possibly to Justin. Essentially just sort of digging into how can others, or how did you yourselves get involved with and connected with these PUC proceedings and other sort of legal cases around this. So I might turn to Justin first, and then to Mary.
Yeah, so I got started in energy justice work in Detroit, and we were running energy efficiency programs. And I realized as we were, serving one household at a time, that this just didn't seem like the structural solution that we needed. And so that's what got me interested in how utility rates got set and how program budgets were allocated. And I connected with a local law clinic at the University of Detroit Mercy, and found a colleague there that was willing to support some testimony. And I think I'm on my 10th case or so now, and it takes a while to get comfortable and efficient and to know what you're asking for and even what you're looking at when you do get responses. But I think it was, for me, the idea that hopefully there's some precedent that gets set, or things like the low income discount rate, right, are things that provide benefits for years and for all of the customers, at least all of the low income customers.
Yeah, like Justin, I got involved in this work from energy efficiency from 2008, trying to streamline Massachusetts, the massive funding to multifamily, subsidized multifamily housing. And then that's where I started to discover the whole, how high electricity costs are, gas costs, and how so many people are locked out of what's supposed to be a very good program. So that's why I got started. With energy affordability, I got engaged mainly in the past 7 years because of the push to switch from gas to electric without wanting to face the fact that fuel switching from gas to electricity is expensive. And I decided to make sure that's going to be something that's known everywhere, because it's expensive and we have to do something about it.
No, absolutely. We often in the energy transition talk about fuel switching, sometimes from the supply side, but I think that definitely on the consumption side, given the regressive nature of energy, of the whole energy system, I think that that's a hugely important topic to get through, and needs a sort of a public policy element to addressing. I've also got a short follow-up. Are there national organizations or sort of regional groups or anything of that nature that could help, both from rolling a couple questions into one here, both from the sort of the community side, but maybe also the legal side, for a lot of our audience, sort of building off of how can advocates effectively facilitate this involvement with communities. So I'll turn maybe to Jolette and Kurt if there are any organizations, or maybe Justin. I think you might run an organization that might fit under that umbrella. So.
Well, I have two thoughts with respect to the question. I can certainly say in Massachusetts, there are several organizations, community organizations, and we talk on a regular basis. And it's nice because we have that support and camaraderie with each other, and we can really keep abreast of what is happening in communities. And I think it's very gratifying that communities will call. They may call Mary, they may call me, they may call someone else, but it's nice to have that type of relationship, because what is so key, in my opinion, is building trust. in communities. And that's not to say that we always align on every single issue. No, but we know that we're listening to each other and that we're trying to move forward in a way that's affordable and that will benefit the community. As I indicated in my talk, the stakeholder working group, we knew we needed to go to the community. And likewise, EDF has the same position. We want to hear from the community. We don't live in every community. We don't know what they're thinking. So to answer the question, in Massachusetts, at least, there is camaraderie and a lot of connection among many of the community groups. Kurt, you may have more to add.
Yes, as far as national groups, I would, if folks want to Google the community, the Community Energy and Engagement Network, SEEN. It's a really good organization. Treasurer Gregory Norris was an expert, a community expert witness for us in a Southern Illinois grid plan case. They'll have some good experiences to share with you if you want to reach out to them. Yeah.
Tom, if I may add one other thing, I don't want to overlook community voices in energy. There is a link to that at the end of Kurt's slides and at my slides. But one of the purposes of community voices in energy is to create a website whereby there can be shared information nationwide regarding connections, advocacy, and important topics in the energy space for those advocates who want to get involved.
That's wonderful. Thank you. Justin, please.
Yeah, I'm gonna add a link to the chat, but we just put out a resource that's compiling our own journey as a witness and what we've learned along the way, and also considerations if you're thinking about, do I want to intervene? Is there some better role for me as an advocate? It kind of walks through some of that and provides some additional examples from testimony.
Thank you all. Those are excellent resources. As Madison and Sarah have mentioned, we should be sharing all of our presentations and other literature with all of you after this webinar concludes. I wanted to now, as a public utility and electricity nerd, I wanted to get into a question that we had in the chat about. Can you maybe, this might go to Justin, and I welcome all of our panelists to weigh in too. Can you talk a little bit about the difference you see, if there is any, between more public utilities and some that are less regulated or have private utilities or private generating companies? I think that the legal term is integrated utilities and not integrated utilities. Have you seen any difference nationally on that metric, or is that a statement that we kind of, it's hard to generalize?
Yeah, I think there's good data that rates are lower if you are in a publicly owned utility or served by one. There are some other factors that influence that, like if they are serving a small, denser community, right? They may have lower distribution costs, which contribute. But I think, yeah, if you take out this chunk of profits that's necessary from an investor-owned utility, right? That's funding that is used or directly lowers your bill in response.
Thank you for cleaning up my lack of legal training on the terminology there. So we also had another question come through on sort of what states are doing. How do you think that effective state energy policies can produce consistent results when states are using sometimes very old sort of legal structures? We had an example come through from Maryland, which it looks like has a public services commission, and it regulates utilities differently than it does in certain other jurisdictions. So any thoughts on sort of the variation in the age that some of these sort of legal procedures take place in?
I don't know if this answers all of the question, but I think honestly that's where advocacy becomes so important. Because if, let's say that Maryland or any state looks at what, or the commission looks at what is being done in another state, that may help foster the discussion to changes. That's why it's important that we get people to the table with different voices so that they can bring that information and, if possible, put it in as record evidence so it can be considered. And obviously that's really important, since commissions will only should only make decisions based on record evidence. It's like how to get information into before regulators that will help shape and possibly change the dynamics that currently exist.
And I would say, in addition to advocacy, I would say not just for commissions, but like Office of Public Counsel. That question from Joe earlier in the chat, like a well-funded staff, a well-funded Office of Public Advocate can make a really big difference. And commissioners who are willing to take an active role and not a passive role, commissioners who know that they are there to regulate. And usually, like the economic theory there is that you're imperfectly regulating in place of an imperfect monopoly market.
Mm-hmm.
So understanding that customers have demands, that they want affordable energy, they want fair prices, they want clean energy. They don't want to have to worry about what the next energy bill is going to be. A good energy regulator is going to understand what those customers want and need. And so I would recommend for public commission staff, commissioners, public advocates out there, look at the complaints. You usually have better access to the complaint files that are filed with the commission. Try to notice any trends. You might even find a customer who's going to provide a really good illustration or vignette on something that your office is noticing. Maybe you can turn a complaint into some witness testimony and really help that customer out, not just individually, but help out a lot of other customers in that situation. It might be disconnection practices. That's something that definitely happened in Illinois. We noticed some disconnection practices that that landed on our radar, and that led to some community witness testimony. It might also be meter reading practices, billing practices, getting bills out on time and accurate and not estimated bills. That's especially a bigger problem with smaller utilities that don't have necessarily the advanced meters that can do accurate meter readings automatically. Other issues like that, time to reconnect after a storm, things, you might be able to find a customer who had a bad experience, a business owner who was affected by a storm outage or something like that. Those things can really be powerful at the commission. And if you let them sit in a complaint file unaddressed, it might not get addressed. But if you find that customer, reach out to them, relate that experience in a rate case or other relevant proceeding, I think it can have a big impact. So.
I have something to say about that. One, I think we have to be very honest with ourselves. There is failure in the entire system. So we cannot look at, we cannot we cannot even use the word effective in the same sentence with something that is 100 years old, because something is broken in our system. And when we look at these rate cases, they should not be viewed using the eyes of academics. They have to be viewed using the eyes you have to see them through the eyes of the people. And those are the statistics that Justin provided. This is not, it shouldn't be business as usual. Here's a rate case. All right, this is what I've been doing all these years. And then you do it 1, 2, 3, 4, finish. And then use the same words as fair, just, but it's fair and just for who? So for me, that's really important. There was also a question on public and private. I no longer think it's about public and private. I think it's about the values. You can be public and not have values that are consistent with equity. You can be private and have values that are consistent with equity. We just saw in our energy affordability hearing, what's supposed to be public or municipal light companies fight energy efficiency to keep their prices low. But I mean, think about it. So you don't want to advance, you don't want to make things better for your customers, to keep your prices low. And are they really low? And they are low for who? So I think we have to open up our minds and no longer be limited by the academics part of this work.
Justin, any follow-up before I'm gonna run to a round robin here, but I want to give you space.
Just very briefly, I noted there are dedicated equity dockets that consider a range of issues, whether it's procedural access, whether it's talking about who gets access to heat pump programs. And I think those are a good practice to modernize the mandate that PUCs have.
That's fantastic. I really like that sort of message that there's an element to which we need to reassess the 10,000 feet, right? The picture that the way it all fits together. We are coming up towards time, but I wanted to make a little space just for sort of parting thoughts. Any advice that you have for any of our participants who are, stalwartly sticking through? And I might ask to go in speaking order. So Justin, if you want to take a first, 45 seconds for your takeaways.
Yeah, just from listening to the panelists, I think it's easy to want to lead with the data in these technical proceedings. And I think it's actually the human stories that are probably more powerful and rarer actually for commissioners to encounter. So I think this idea to bring in community witnesses is just really, really critical in these spaces. Because we can't be the ones saying we need affordability. It means so much more when somebody has that direct story. I just got a call this morning from somebody who had given birth yesterday and was working to try to get her electricity restored, and the company didn't accept a medical exemption form that she submitted because birth apparently is not on the list of protections, and I can just imagine what that story would mean for a commissioner to have to sit with that and think about the protections that are needed.
Absolutely. Kurt, your thoughts.
Yeah, I don't want to steal Mary's thunder, but exactly what Mary was saying, like getting commissioners to look at these issues through the eyes of the customer, to answer maybe a question that was in the chat earlier is, how do you integrate community witness testimony and like a reliability docket? And the challenge that we see is getting commissions to look at things holistically. It's very for a long time, commissions have realized this is a huge undertaking to regulate the power industry. So we're going to have an energy docket, an energy efficiency docket here, a reliability docket here, grid mod over here, rate design over there. Things tend to get siloed a little bit. And that takes away from that holistic approach. Like customers don't experience energy efficiency separately from demand response, separately from rate design, separately from grid modernization. They experience it as an integrated whole. And so that's really how commissions need to be looking at it. And that can be a challenge when you have dedicated dockets. But there's still space in those dedicated dockets to understand how that one docket fits in with a larger picture. So.
Wonderful. I'm going to flip the script a little bit here. So, Jolette, I hope I'm not putting you too on the spot if I asked you for your final thoughts here next.
No, absolutely. And thank you for the space to give my final thoughts. I absolutely echo what Justin said. And the way that I look at it is that commissioners are people too. I mean, the human element, it transcends whatever title you have, whatever space you're in, we're all human. And to bring that to the table in a very persuasive way is so valuable. And again, I could write down certain points and certain things I would want to advance. But if I'm not the person being affected, it's not going to be as persuasive as someone who will feel the impacts. And along with that, I think it is important to not to be afraid to bring to the table relevant but novel ideas to move certain issues forward, like affordability. We need more thought on that, and we need to solve it quickly. We've seen the numbers today about the rising rates, about the increase in unpaid utility bills because people can't afford it. So we need a lot of new thinking on this issue, and that should be brought to the table.
Thank you so much, Gillette. And Mary, take us home. Parting thoughts for our audience.
I mean, for me, one is just gratitude that that people like me get to have the kind of help that I've received from EDF and many others. And my parting thoughts are that each person should think of themselves as the person that cannot afford energy. Because if you think about it that way, it will recalibrate your actions going forward. Thank you.
That's perfect. And I think an excellent note for us to sort of move towards concluding on. So please, virtually join me in thanking all of our excellent panelists. It was a real pleasure to get to hear from all of you. Big takeaways for me were, looking at this from a people-centered perspective. I think that is often lost in in the technocratic sort of perspective that I bring myself. And also just, ensuring that while this remains, so central to the discussion, that it does remain so central, right? This is suddenly we have seen this incredible, expansion of discussions around electricity, increasing demand, how are we going to do a transition? Is there a transition happening, right? Like it can be very easy to get lost in noise, I think, in this space. And I think that, a clarion call from all of our speakers here today and from this webinar series is to make sure that we put people first and put people at the center in how we're thinking through these questions. So those are my thoughts. Madison, if you have any more sort of housekeeping things that we need to go through before we say sayonara to everyone. So
Thank you so much to our speakers, Justin, Kurt, Mary, and Gillette, for taking the time to join us and present on this important topic. We truly appreciate your time and energy. Thank you to Tom for moderating, and to Jenny Freeman, Sonia Jindal, and Micah Krause as well for their assistance in organizing this webinar. And thank you to our audience for tuning in. We appreciate your engagement. Thank you all so much. We have another community lawyering for environmental justice program scheduled for October 20th. It will discuss environmental pro bono opportunities in the DC region. We hope to see you there. Have a great day, everyone.